The Supreme Court's docket just became our best chance for victory. After years of watching courts gradually erode our Second Amendment rights, the United States Supreme Court is finally stepping in. This term, the court has quietly added several monumental cases that could reshape gun ownership laws across the country. Among the challenges are California's ban on standard capacity magazines, Washington's prohibition on detachable magazines, Cook County's assault weapon ban,
This is one of truly the strongest and best assault weapons bans in the entire country.
and the federal law preventing nonviolent felons from possessing firearms. Some cases examine restrictions on carrying firearms in Hawaii and the federal prohibition against firearms for unlawful drug users. If the court applies the Bruen framework, we could see a historic affirmation of our right to bear arms, one that could undo decades of unconstitutional restrictions. Join me as we break down these critical cases and explore why our vigilance in these battles matters now more than ever. The United States Supreme Court is poised to confront a sweeping array of Second Amendment disputes that could reshape the legal landscape for gun regulation across the country. Over the past decade, the court's jurisprudence has shifted dramatically, moving from the interest-balancing approaches that many lower courts use to uphold restrictions to a strict history and tradition framework established in New York State Rifle and Pistol Association versus Bruen in 2022. That doctrinal pivot has invited renewed challenges to state and federal laws that regulate firearms, accessories, and the rights of particular categories of people to possess weapons. A cluster of high-profile cases now awaiting the court's attention touches on detachable magazines, bans on semi-automatic assault rifles, lifetime disarmament of people with felony convictions, restrictions on carrying firearms on private property open to the public, and federal prohibitions on firearm possession by unlawful drug users. The outcomes could either entrench Bruen's historical test as the dominant standard for evaluating modern gun laws or carve out exceptions that preserve broad regulatory authority for legislatures. At the center of the immediate controversy are state laws that ban detachable magazines capable of holding more than 10 rounds. California's Penal Code 32310, enacted in 2016, prohibits possession of such magazines and has produced years of litigation. After the law's passage, a brief enforcement pause known as Freedom Week allowed tens of thousands of residents to purchase standard capacity magazines before the ban took full effect. Federal District Judge Roger Benitez twice found the California ban unconstitutional, concluding that magazines are arms in common use and that the prohibition could not survive constitutional scrutiny. Those rulings were reversed on March 20, 2025, when the Ninth Circuit, sitting en banc, held that magazines are accessories rather than arms, that the state's ban aligns with a long tradition of regulating particularly dangerous weapons, and that the restriction does not meaningfully burden the core right of self-defense. If the Supreme Court declines to review the Ninth Circuit's decision, the ruling will stand, and Californians who possess standard magazines could face the prospect of surrendering or permanently disabling property that many consider essential to the function of their firearms. A parallel development in Washington state has compounded the legal uncertainty. On May 8, 2025, the Washington Supreme Court, in State versus Gators Custom Guns, concluded that magazines are not arms under the Second Amendment, and therefore fall outside its protection. The court relied heavily on legislative findings that high-capacity magazines increase casualties in mass shootings, and that restrictions on such magazines reduce gun deaths. Retailers and industry groups argued that the law criminalizes standard equipment for semi-automatic rifles and handguns, but the court framed the restriction as a reasonable safety measure. Petitioners seeking review in the U.S. Supreme Court received a distribution of their petition for the court's December 5 conference, and the case has attracted numerous amicus briefs on both sides. The central legal question presented by the petitions from California and Washington is straightforward in form but complex in consequence. Are detachable magazines arms protected by the Second Amendment, or are they accessories that states may regulate or ban consistent with historical tradition? Those who challenge magazine bans emphasize that detachable magazines are integral to the operation of modern semi-automatic firearms, and that they have been in widespread use since the late 19th century, which, they argue, places them squarely within the category of arms in common use for lawful purposes. Critics of the Ninth Circuit's en banc decision contend that treating magazines as accessories conflicts with District of Columbia versus Heller, where the court recognized that the government's inability to ban the quintessential self-defense weapon was decisive. The Washington decision complicates the picture further by grouping magazines with other firearm attachments that the court deemed outside the amendment's protection. A Supreme Court grant of review could resolve a split among state and federal courts and determine whether magazine bans are permissible under the Bruen framework. A denial would leave the divergent rulings in place and likely encourage other states to adopt or tighten similar restrictions. Another major front involves bans on semi-automatic rifles, often labeled assault weapons, including AR-15-style firearms. Since 1993, the most populous county in Illinois has prohibited possession of certain semi-automatic rifles, and in August 2025, the Seventh Circuit reaffirmed that county's ordinance. The Seventh Circuit reasoned that semi-automatic rifles are essentially the same as military-style firearms and therefore fall outside the core of the Second Amendment. The court dismissed evidence that millions of AR-15s are owned for lawful purposes, such as self-defense and sport, concluding instead that the weapons designed for combat justifies restriction. Challengers, including the Second Amendment Foundation and the Firearms Policy Coalition, filed a certiorari petition arguing that AR-15 platform rifles are the most popular rifles in the country and that bans on them violate both the Second and 14th Amendments. They urged the Supreme Court to settle the assault weapon ban issue once and for all, contending that multiple federal circuits have misapplied Bruen. Respondents counter that the ordinance is narrowly tailored to reduce gun violence. The petition was distributed for the court's December 5th conference. A grant could produce a ruling that either invalidates assault weapon bans nationwide or upholds them under a historical tradition analysis, while a denial would leave conflicting appellate rulings intact and invite continued litigation. The constitutionality of lifetime disarmament for people with felony convictions is another issue generating circuit splits and petitions for Supreme Court review. Federal law, codified in the Gun Control Act of 1968, makes it illegal for anyone convicted of a felony punishable by more than 1 year in prison to possess a firearm, regardless of whether the underlying offense was violent. Historically, courts have generally upheld this prohibition, but Bruen's history and tradition test has prompted renewed challenges, particularly when applied to nonviolent felons whose convictions may be decades old. In 2023, the Third Circuit held that Brian Range, convicted of a nonviolent welfare fraud offense, retained Second Amendment protections because the government could not demonstrate a historical tradition of permanently disarming nonviolent felons. That decision created a split with other circuits. In 2025, the 10th Circuit in Vincent v. Bondi upheld the law, finding that disarming felons has a long pedigree, and that precedent such as Rahimi did not displace that tradition. The Ninth Circuit, in United States v. Duarte, also upheld the law on May 9, 2025, agreeing that bans on gun ownership for felons align with Bruen and Rahimi. Petitioners seeking Supreme Court review argue that Bruen requires the government to show historical analogs for disarming nonviolent individuals and that many people with old nonviolent convictions should not be permanently stripped of their core right to self-defense. A favorable ruling for petitioners could restore firearm rights to hundreds of thousands of Americans. A denial would leave the circuit split unresolved and the issue to Congress or future litigation. The court is also set to address state laws that flip the default rule for carrying firearms on private property open to the public. In response to Bruen, states such as New York, New Jersey, California, and Hawaii enacted statutes that require property owners to affirmatively post signs permitting concealed carry on their premises, effectively barring permit holders from carrying on most private property open to the public unless permission is posted. Hawaii's law, for example, designates numerous sensitive places where firearms are forbidden and bars permit holders from carrying on private property open to the public unless the owner posts a sign allowing it. The Ninth Circuit upheld such a law and rejected an en banc rehearing, prompting 3 Maui residents and the Hawaii Firearms Coalition to petition the Supreme Court. The U.S. Solicitor General filed a rare amicus brief urging the court to hear the case, noting that similar restrictions now apply in states encompassing more than 1/5 of the U.S. population. The court granted review in Wolford v. Lopez in October 2025, setting the stage for arguments in early 2026. The case will test whether states can effectively render public carry illusory by shifting the burden to property owners to permit firearms, and whether post-Reconstruction regulations relied upon by lower courts are adequate analogs under Bruen. Finally, the court has agreed to hear a case that probes whether habitual users of illegal drugs may be disarmed under federal law. The Gun Control Act prohibits anyone who is an unlawful user of or addicted to any controlled substance from possessing a firearm. In January 2025, the Fifth Circuit struck down the statute as applied to a marijuana user, reasoning that there is no historical justification for permanently disarming a sober citizen not presently under an impairing influence. The Justice Department appealed, and the Supreme Court agreed to hear United States v. Himani, a case involving allegations that a defendant was a regular marijuana user whose pistol was discovered during an FBI raid. Petitioners argue that Bruen requires the government to demonstrate historical precedent for disarming nonviolent, sober individuals based on drug use. A ruling in favor of petitioners could have far-reaching consequences in states that have legalized marijuana but remain subject to federal prohibitions. Taken together, these cases present the Supreme Court with a menu of consequential choices about how to apply the Second Amendment in the modern era. If the justices insist on rigorous historical analogies for every modern regulation, many contemporary gun laws could be vulnerable. If they carve out exceptions or allow more deference to legislative judgments about public safety, states may feel emboldened to maintain or expand restrictions. Either path will have profound implications for public safety policy, criminal justice, and the rights of millions of Americans. The coming months and years will determine whether the court reaffirms a robust, historically grounded protection of the right to keep and bear arms or permits a broader scope of regulation in the name of contemporary public safety concerns. Observers on all sides of the debate are watching closely, aware that the court's decisions will not only resolve the immediate disputes, but also set precedents that will guide lower courts and legislatures for generations. We stand at a crossroads. Either the court will honor the Constitution and our history, or it will allow infringements to proliferate. Stay informed, share this message, and support those fighting for our rights. Stay ready, stay armed, and stay free.